Before we begin, it is important to state the following disclaimer clearly. This explainer is for educational purposes only and is not a substitute for legal or immigration advice. The information presented is based on public guidelines as of 2026. You must always verify details with official UAE government sources for your specific circumstances.
One of the most common points of confusion for individuals seeking employment in the UAE is the process of converting a visit visa to a work visa. It's a pathway many consider, but it is subject to significant misunderstanding. This explainer will clarify the official rules based on published government guidelines to provide a factual and accurate understanding of this critical process.
You have likely heard some version of this advice. It suggests a simple, almost seamless transition from visitor to resident employee. The statement implies that the process is straightforward and carries very little risk.
This belief, however, is dangerously incomplete. Operating on such a partial understanding of the law can lead to severe legal and financial consequences. While an in-country status change is indeed possible, it is a formal procedure governed by strict regulations. Misunderstanding these rules creates substantial risk for the applicant.
To provide a complete and accurate picture, we will proceed through these 6 key areas. We will begin with the half-truth about a visit visa's purpose, then outline the official legal pathway. After that, we will define illegal work and its consequences, explain how in-country conversion actually functions, debunk the myth of guaranteed approval, and finally, discuss the permanent nature of your immigration record.
Let us now address the first point, the dangerous half-truth. To fully grasp the risks involved, we must first establish the specific legal purpose of a visit visa, as this forms the foundation for all subsequent rules.
According to official UAE guidelines, a visit visa grants temporary permission to enter the country for specific purposes, like tourism or short visits. In the context of a job search, its sole legal function is to permit your physical presence in the country to attend interviews and secure employment. It is explicitly not a permit to perform any kind of work, whether paid or unpaid. This distinction is fundamental.
So, if one cannot work while on a visit visa, what is the correct procedure? We will now outline the official, legally mandated sequence of events that must be followed to secure employment and residency.
The official pathway is defined by a precise sequence, and adherence to this order is mandatory. First, you enter the UAE legally on a valid visit visa. Second, you secure a formal, genuine job offer from a properly licensed employer. Third, that employer, and only the employer, applies for your work permit through the official government channels. Fourth, only after that permit is approved can your visa status be officially changed. Finally, the process concludes with the mandatory medical tests, Emirates ID registration, and the stamping of your residency visa.
Let us be very clear on this point. As an individual applicant, you cannot apply for your own work visa. The entire application process must be sponsored and initiated by a registered UAE employer. This is a non-negotiable requirement of the system.
What then constitutes illegal work while on a visit visa? And what are the official consequences for such violations? Let us now examine the prohibited activities as they are defined by the law.
According to official enforcement guidelines, the term work is defined very broadly. It prohibits any form of employment, whether compensated or not. This includes so-called trial work, any form of training, providing freelance services, assisting in a family business, or even performing online work for a UAE-based company. For example, if an employer asks you to begin an unpaid training period while your permit is still being processed, that is a direct violation of the labor law.
It would be a significant mistake to assume such activities go undetected. The authorities utilize several enforcement mechanisms, including physical workplace inspections, audits of company payroll records, and systemic data matching between the immigration and labor ministries. Violations are systematically identified and recorded.
We will now turn to the mechanism for in-country visa conversion. This is a topic where misinformation is particularly common, so it is vital to understand precisely how it functions within the official framework.
So the question is, can you change your visa status without leaving the country? The answer is yes, this administrative facility does exist. However, it is not a simple or automatic step. It is a conditional process that is governed by very specific rules.
According to the official guidelines, an in-country status change should be understood as a facility offered by the government, not as an automatic right of the applicant. Its approval is not automatic, it is not guaranteed, and it is not instant. It is entirely conditional upon the successful completion of all preceding legal requirements by both you and your employer.
The outcome of an application is heavily dependent on the sponsoring employer's legal standing with the authorities. For example, let's consider two identical candidates. Candidate A's employer is fully compliant with all labor laws and submits all paperwork correctly. Their application is likely to be approved. Candidate B's employer, however, has unresolved compliance issues or problems with their hiring quotas. Their application is likely to be rejected, which could then require the candidate to exit the country.
Now here is a critical point of personal responsibility. You are required to maintain your legal status at all times. If your visit visa expires while your work permit application is being delayed by the employer, the resulting overstay fines are your personal liability. These financial penalties are not waived due to an employer's processing delays.
Let us now address what is perhaps the most common and dangerous misunderstanding: the myth that possessing a job offer letter guarantees a successful visa conversion. When authorities review a work permit application, they consider a specific set of official criteria. Factors that positively influence an application include an employer with a clean compliance history and a clear alignment between the job role and your documented qualifications. Conversely, factors that have no bearing on the official decision include verbal promises from the employer, a third-party agent's guarantee, or the flawed logic that everyone does it. These factors are unofficial and completely irrelevant to the legal process.
Let us be perfectly clear on this matter. A job offer letter is only the beginning of the process. It is not, in any way, a visa approval. The subsequent stages, including the work permit issuance, the medical fitness examination, and the mandatory security screening, must all be successfully cleared before residency can be granted.
Finally, it is essential to consider the long-term perspective of your permanent immigration record. Every interaction that you have with the UAE's immigration system has a lasting impact. Your immigration file in the UAE is a cumulative record. Every entry, every exit, every application, and particularly every violation, such as an overstay, is logged permanently against your name in this file. This creates a complete and indelible history of your interactions with the authorities.
Adherence to the rules is critical because the system remembers patterns. Past incidents like an overstay or a recorded illegal work violation are not erased. They remain on your record and can negatively influence the outcome of all future applications you might make for residency or even entry permits. The system is designed specifically to identify patterns of non-compliance.
In conclusion, the process of changing from a visit visa to a work visa is a strictly regulated procedure, not an informal arrangement. Within the UAE's immigration framework, compliance is not optional. Understanding and following the correct legal sequence is paramount because a minor violation today can become a significant and permanent obstacle for your future in the country.